Welcome everyone to another episode of C4NPR Chats. I am delighted that Patty Wise of Spangler-Nathanson is back with us today. She's going to share her observations of where we are specific to regulations, legislations that impact the employer-employee relationship. So welcome, Patty.
Thanks so much, Heather. Thanks for having me back.
Yeah, and I know that we're using this phrase a lot. We're all drinking from the fire hose, so I don't want to keep you any more than we need to. So how about we jump right in?
Sounds good.
Okay, so let's start with this acronym that's flying around the community. What does FFCRA mean?
Right, we're seeing that everywhere. It's maybe the most significant piece of legislation we have seen for employers, providing some different types of leave for employees. What it stands for is Families First Coronavirus Relief Act. And not only was that law enacted back in March, it seems so long ago now, but it has been revised through Department of Labor guidance, not just daily, but several times, sometimes within a day. So it is something we're really trying to stay on top of, but it is, again, very, very significant for employers. So, excuse me, if we can talk about that a bit today. And as I've told you before, and don't be alarmed, anyone, I don't think that I have any symptoms of the virus, but I've been talking so much to so many people with questions that I'm losing my voice a bit. But I cannot answer, as I've shared with you before, Heather, and I think we've talked about before, specific questions, since I don't have an attorney-client relationship with all of your listeners. But we certainly can talk generally about this legislation and other issues that people are facing right now.
And I know that is much appreciated in our nonprofit leaders community. You bring up a good point. I want to date this conversation Monday, April the 6th. This is what we know as of 10:13 this morning, and who knows what we're going to know by noon.
That's right.
But Patty, how about we start with what are some of the things that are most important that people know about this legislative requirement now?
Well, there are, as I said, two basic types of paid leave, and that's unique. We don't have paid leave from the federal government. We haven't had that before enactment of this act. And so for the period of time right now, the period of time between April 1st of this year through the end of this calendar year, December 31st, we have this paid leave legislation that applies to mostly all employers and includes nonprofits that have fewer than 500 employees. So it's going to provide two different types of potential paid leave for employees in most cases. So that's a very big departure from any law that we have seen that is applicable to employers.
Okay, so are there potential situations where employees are exempt from FFCRA?
There can be, and it is, and I'm glad you said employees, because we had, I think, originally maybe anticipated that there would be certain employers who were exempt, so employers of 50 or fewer employees, and that is not the case. There's not a wholesale exemption for an employer. The exemption is always employee specific. And so if, for example, an employee who maybe requests paid leave under this act is an employee that is so essential for the employer's operations that employee maybe has some unique skills or responsibilities, and the employer could not continue their operations if that employee were to be absent, then the paid leave could be inapplicable to that particular employee in that situation. And again, they're very fact specific on a per employee basis, but there are some exemptions.
Mm-hmm. So as you look out into our community, well, let me ask this another way. Do you have clients asking for your guidance if they run into a situation where they have an employee or employees who are afraid to come to work?
Yeah, that's so common right now, and I really wanted to mention just the anxiety that everyone is feeling right now. So that is a pretty common kind of response among employees. And it was interesting, I was kind of doing a little research on this, and SHRM had just announced that in 2019, 94% of US employees reported experiencing some work-related stress. That was in 2019. So we don't have much room there before really everyone, and I do think it's a very, very stressful time. So we want to be, what I'm telling employers is we want to be very considerate of someone who says they're afraid to come to work, right? That's the time we live in. There are so many reasons that any person or all of us could have some anxiety about going to work. So we don't want to be judgmental. That does not mean, though, and probably doesn't mean, that they're entitled to paid leave. So just a fear, and I don't mean to minimize that, but having a fear without some maybe underlying health condition or something that a medical provider has suggested it's best that the person not be in the workplace, that fear alone is probably not enough to justify paid leave. But again, having said that, I think we all need to be as empathetic as we can in a very stressful situation.
So is there anything that you would like to share that I haven't yet asked around this topic?
Well, I think it might be good to take a couple of examples of the kinds of things that we're seeing a lot of in terms of what employers might be facing. Let's talk about that employee who might want to be taking advantage of the paid sick leave. So the paid sick leave portion of the FFCRA provides up to 80 hours for full-time employees. And the reasons for that can be related to the employee themselves. So it might be that they've, as we talked about, been advised by a healthcare provider that they should be out of the workplace, or that they're actually experiencing symptoms and looking for a diagnosis or looking for some assistance from a healthcare provider. That's a basis for that paid sick leave. Also, a person, the law allows that when an employee is required to care for an individual who is subject to that kind of order, so that person has been advised to stay out of the workplace, there can be coverage for that. And notice I said individual, so that's not limited to a family member. And then a big category that we're seeing a lot is to provide childcare. So we know that childcare providers, schools are closed. So when an employee is required to care for someone, a child, and the age we're really looking at here is younger than 14. So the idea is that the employee is required to care for that child during daylight hours, and that's why we have the 14-year-old cutoff. That employee will probably qualify for 80 hours of fully paid leave. Now, keep in mind, there's no waiting period for this. So if this is an employee who came to work for you the end of March, they're entitled to this leave as of April 1st. There's a maximum of $500 a day for compensation. And again, the employee can't just decide that they would prefer to stay home or that they're too afraid to come to the workforce. So those are some of the reasons we're seeing requests for employees to use that paid sick leave. There's another category that we have not seen yet developed, and that is for substantially similar reasons. So the Department of Labor will be issuing some guidance on that, and they are the government agency charged with implementing this. So we're likely to see some more examples of the kinds of things that could allow an employee to qualify for leave. So that's I think the most common request, that request for that paid sick leave. Also, employers get a tax credit for that. So when an employee properly requests and is granted that paid leave, the employer then gets a corresponding dollar-for-dollar tax credit. And so it should be revenue neutral for the employer. You've got to get, though, the documentation to support the justification for the leave, or the employer may not get that tax credit. I think the other thing that we're seeing a lot, and it's related to that childcare issue we just talked about, there is a new reason for requesting FMLA. So for those nonprofits who have 50 employees or more, they've been complying with FMLA for decades now, and so they know a fair amount about it. But if you remember at the beginning, we talked about the fact that the FFCRA applies to all employers with less than 500 employees. That means that you are going to have employers of fewer than 50 people who have never had to comply with the FMLA, who will need to provide this right now, this emergency FMLA, which is paid in this specific situation. And it's only for the child care situation we described. So that one is being the subject of a lot of discussion, I would say, for all employers, but especially those who haven't been subject to FMLA in the past.
Wow, that's a lot, particularly for some of the smaller nonprofits that haven't had this requirement before.
Absolutely. And just for their benefit, I mean, just to talk a little bit about it, because it's pretty complex. The first 2 weeks of this emergency FMLA would be unpaid. Now, chances are the person would also qualify, as we just talked about, for that paid sick leave. But after the first 2 weeks of the FMLA for childcare, the employee would be entitled to compensation at the rate of 2/3 their regular rate of pay, and there's a $200 a day cap for that. Again, remember, the most important thing here is it's only available for that child care situation, and that child care is for children less than 14, unless there are special circumstances. There could well be special circumstances. So if you're going to be providing that type of leave, that's another area where you have to have the documentation. So you're going to need the documentation that either the child care provider is closed. It could be as simple as an email from the neighbor who usually watches your child, saying that he or she is unavailable to take care of the child. And then if you've got a child or children who are 14 or older, who for some reason, some special circumstance, need care during daylight hours, then you're going to need documentation of what those special circumstances are. The qualifier with that, while the paid leave that we talked about, the emergency paid sick leave, is immediately available, to qualify for the emergency FMLA, an employee needs to have been with their employer for 30 calendar days prior to the leave request. So when you say this is complex, especially for those who haven't had to work with FMLA before, it absolutely is. And even for those employers who have had FMLA for many years, this is an entirely new category of FMLA, and it has different requirements. So it is absolutely complex.
Well, thank you for taking the time to brief on what we know sitting here today, Patty. I know that there was great feedback from some of the tools that you had shared before, some of the PDFs and things. So
right, and I know your website is a collection of resources for employers, so I think that's really helpful as well. So hopefully employers can turn to that for some additional information.
Great, thank you. Yes, so if you're listening and you're not aware, on our website, C4NPR.org, there is an information and resource page. Nicole has been working to compile all of these resources. There's grants and funding, and then there's these trusted insight, partner insights, of which these briefings with Patty, that's in that collection. There's some guidance that came out from the Lucas County Health Department on handling positive COVID-19 cases. I mean, you'll see it all out there. There's dozens and dozens of links. If you need anything else, please reach out to us and we will attempt to research it for you. And Patty, as always, we welcome your guidance, and as things change, we welcome any help that you can provide to our nonprofit community.
All right, well, good luck to everyone, and everybody stay well. Thanks, Heather.
Thanks. So we'll welcome you to another episode in the future of C4NPR Chats. Thanks for listening.